Hello and welcome to LiveLaw Academy. In this session, we will understand the application of res judicata in criminal cases. Recently, the Supreme Court in SC Garg versus State of UP has held that res judicata applies in criminal matters as well. We will see how. But let's begin with very basic things. The term res judicata, it comprises of two things, res and judicata. Res means matter and judicata means already adjudicated. It simply means that an issue which is already decided between the parties, the same issue cannot be brought back to the court again and again by the same parties when they are in the same capacities. The same facts cannot be relitigated again and again. The underlying purpose is to avoid unnecessary litigation, to bring an end to it, to avoid unnecessary harassment of the parties, and also to prevent wastage of judicial time. And the same thing is mentioned in section 11 of Code of Civil Procedure. And it is normally seen that res judicata is a civil phenomena. It is applicable in civil cases, but it is also applicable in criminal cases. And the essence of res judicata is captured in a Latin maxim, Intrust Republicae ut sit finis litium, which means it is in the interest of the state that litigation comes to an end. In fact, it is in everybody's interest, right? So as I've told you that this is also applicable in criminal cases. One such case is in which it was held, Bhagat Ram versus State of Rajasthan. You can note down the citation also. AIR 1972 Supreme Court 1502. In this case, the Supreme Court held that findings of fact in a criminal case can act as res judicata. That means if court has conclusively decided an issue of fact, then that finding is binding in the later proceedings on the same issue between the same parties. But here it is important to understand that it is different from double jeopardy. The concept of double jeopardy contained in Article 20, Clause 2 and Section 300 of CRPC, they bar both these provisions, they bar a subsequent trial, a second trial. However, res judicata in criminal cases does not bar the trial. It blocks the evidence being given on the same issue on which a finding of fact has been already given, right? In subsequent criminal proceedings, it cannot be given in evidence. If the evidence is blocked as to the same finding of fact. Right? This is the application of res judicata in criminal cases. Another important decision is Pritam Singh versus State of Punjab. This is a landmark decision. Pritam Singh versus State of Punjab, AIR 1956 Supreme Court 415. In this case, it was a decision which was given by a 3-judge bench. In this case, it was held that res judicata equally applies to criminal cases, and to hold this, the court relied on a quote from a previous decision given by Privy Council in Samba Sivam versus Public Prosecutor 1950 AC 458. AC stands for appeal cases. 1950 AC 458. I'm reading the quote for you. A verdict of acquittal is binding and conclusive in all subsequent proceedings between the same parties. On this quote, the Supreme Court relied and said that the principle of res judicata equally applies in criminal cases. Now let's see the recent case of SC Garg versus State of UP. Let's see what has happened in this case. So Mr. Garg was a managing director of a company which was in business with another firm owned by Mr. Tyagi. Between December 1997 to January 1998, between December 1997 and January 1998, 11 checks were issued by Mr. Tyagi in favor of Garg's company, but they bounced. Then mutually, it was decided by the parties that after some time, these checks can be presented again for encashment. Meanwhile, some demand drafts were also executed by Mr. Tyagi, but this was for some separate liability. It had no connection with the previous liability, which was sought to be discharged through checks. They had no connection. When the checks were again presented as per the mutual understanding of the parties, when they were again presented, only 4 of them got cleared and rest again bounced. So a criminal proceeding was initiated under Section 138 of NI Act against Mr. Tyagi. And in 2002, the magistrate convicted him. His main defense was that his liability was discharged through the demand drafts that were executed later. But the court rejected this argument and said that these two liabilities were separate. The liabilities that were discharged through demand drafts had nothing to do with the debt which was sought to be discharged through the checks. So this was an issue on which a finding was given by the court. Then there were appeals, but the matter was finally settled between the parties in terms of the decision which was already given by the magistrate. So finding of fact remained intact. Now what happened later on, Mr. Tyagi filed an FIR against the complainant in the previous case, stating that the checks were again presented and this amounts to cheating, though the debt was already discharged through demand drafts. Now he's trying to flip the narrative. Basically, he changed his capacity from the accused to the complainant, but the facts, they remain the same. So Mr. Garg sought to get the quashing done by the High Court in this matter, but the High Court rejected the application. Mr. Garg, he invoked 482 of CRPC, but the decision was not in his favor, and so he went up to the Supreme Court. The Supreme Court found that yes, in this case, the proceedings should be quashed. Why? Because the Mr. Tyagi is trying to relitigate the same facts upon which a finding has already become final. He is just trying to bring the same issue again before the court. He alleges that demand drafts were executed, so the checks need not be represented to the bank because they had connection with these two had the connection with the same liability, but it was found otherwise already. So there is no need of such an issue to be brought before the court again. There is already a finding of fact on this issue. So the court said that res judicata applies in this case, and the subsequent proceedings initiated by Mr. Tyagi, they will serve no meaningful purpose. They are hit by the concept of res judicata, and as such, the prosecution cannot continue. Right? So this was the basic but core explanation of the concept of res judicata vis-a-vis criminal cases and a recent judgment also. And if you are looking for more such explainers, then you must subscribe to the channel, and you should also hit the like button and start a conversation in the comment box. And if you're looking for some serious judiciary preparation, then you must explore the courses from LiveLaw Academy. That is all as far as this session is concerned, right? Okay. We'll meet again.